Okay. Very good evening, Shalini, Aprajita, Vandana, Bhumika, Samsudwa. Very good evening, everyone. Chaliye. On that note, let's begin with this session. So, first of all, I welcome each one of you to my class on CrPC, one of the most important MCQs. Let's start with my brief introduction. My name is Sandeep Khatri. These are my areas of specialization. As you can see on the screen, the constitutional law, criminal law, commercial law, family law, jurisprudence, and law of torts. Students, I have shared the link of my profile of Unacademy, so make sure you follow that to get all the updates about my special classes and my plus courses. I've also shared the link of my Telegram channel where you can connect with me and ask your questions related to your judicial preparation. At last, I have mentioned my code, that is Khatri10, which you can use to get free access of all the special classes available on Unacademy app. So this was about me. Now I request everyone, please be attentive, and this is going to be an interactive session. So the moment you feel you're not clear with anything, feel free to ask your questions in the comments and I'll answer accordingly. So let's begin with the MCQs. Very good evening, everyone, those of you who have just joined. Very first question from the plea bargaining, that the right of an accused for plea bargaining in India relates to option number A, fact bargaining, option number B, charge bargaining, option number C, sentence bargaining, and option number D, all of the above. Top three students to answer correctly. First one, Dharitri, followed by Aprajita and Kanika. Okay, everyone's answer is correct. Samsudin, Shalini, and Vandana. Everyone's answer is correct. That is C. Students, always do remember when you are writing the question on plea bargaining, there are three kinds of plea bargaining, as you can see in the options as well: the fact bargaining, charge bargaining, and sentence bargaining. But as far as India is concerned, we actually follows the sentence bargaining. So C is the correct answer. The term taking cognizance under provisions of CrPC 1973 means, choose the most appropriate option, taking cognizance. Okay. Top three students to answer correctly: Shalini, followed by Aprajita and Sayantani. Okay, you have mentioned section 190 as well. C is the correct answer, students. That is taking notice of the matter judicially. Can anyone tell me under which section the term cognizance has been defined? Can you tell me the section number where this term cognizance has been defined? Anyone? And we have discussed this question in this series only. So if you have attended the previous classes, you can easily answer. Jyoti, 154. Dharitri, not defined. Tejaswani, 190, 2C. Students, when it comes to section 154, this is basically information about the cognizable offense. So the term cognizance has not been defined. Similarly, under section 190 as well, 190 is basically when a magistrate can take the cognizance. So there are four different situations. So 190 also does not define the term taking cognizance. Finally, 2C, when it comes to 2C, that is cognizable offense or cognizable cases has been defined. So the term cognizance has not been defined anywhere in the CrPC. Okay. Chaliye, moving forward. Protection against double jeopardy contained in section. Do mention the article, relevant article number as well from the fundamental rights. Top 3 students to answer correctly: Jyoti, followed by Shalini and Dharitri. Article 20, Clause 2. I guess everyone's answer is correct. Yes. Under the provisions of CrPC 1973, cognizance can be taken off. Choose the most appropriate options: A, B, C, or D. Yes, Shalini, you may use the maxim as well. Namo debit Vix. Sorry, correct one. Kanika, Aprajita, and Dharitri. Top 3 students to answer correctly. So, cognizance can be taken off only and only of the offense and not about the accused or offender or the witnesses. So, A is the correct answer. Okay. So at the time of taking cognizance, all magistrate needs to confirm is whether the offense has taken place or not, whether it is in the form of police report or in the form of complaint or suo moto or by information. Which of the following requirements need not to be followed under section 200 of CrPC 1973? Top 3 students to answer correctly: Dharitri, Pariksha, and Lela. Okay, there are mistakes in this one. So I'm clarifying. Which of the following need not to be followed? Which means need not to be followed. The complainant must be examined. So answer is yes. What is the heading of section 200? Examination of the complainant. So A cannot be the correct answer. Examination of the complainant must be under oath. This is also something which is completely correct. And the examination of the complainant must be reduced to writing. See, when the complainant is coming with the complaint, that complaint may be oral or may be in a written form. But that must be reduced to writing as per to section 200. But when it comes to the accused must be given an opportunity to be heard. So section 200 has nothing to do with the accused. It is all about the complainant and the witnesses, if any. So there is nothing to do with the accused. So accused will not get any opportunity to be heard as far as section 200 is concerned. So C is the correct answer because that need not to be followed. I hope clear, Shalini. I have already explained this. If you still have any doubts, you may ask. And if it clear, quickly give me a thumbs up. I'll move to the next question. You may go through with section 200 and you will find there A, B, and D, all these 3 options. Okay, now understood. So I can move to the next one. Where the FIR discloses prima facie commission of a cognizable offense and there is delay in sending the FIR to the magistrate under section 157 of CrPC, choose the most appropriate option. Okay, top 3 students to answer correctly: Dharitri, Shalini, and Kanika. And I guess everyone's answer is correct. Yes. Everyone's answer is correct. That is A. The investigation must go on. Okay. Now I have one more question in relation to this one. Can you please tell me under which section magistrate can order for stopping of investigation? Under which section magistrate can order for stopping of investigation? Anyone? $159? No. 159 is not stopping of investigation. No. Anyone else? Students, always do remember there is no such provision where magistrate can order for stopping of investigation. Investigation is part of your, that is the police. And yes, to start the investigation when it comes to non-cognizable offense under section 155, you need to take permission. But that has nothing to do with the order of stopping of investigation. So there is no such provision. So basically, magistrate cannot stop the investigation. Okay. Next. Okay. So that was kind of a trick question. You may expect these kind of questions in your interviews. Very, very easy. But again, this question has been asked multiple times in your exams. A reference under CrPC can be made to. You should not take more than 2 seconds to answer these kind of questions. Okay, everyone's answer is correct. That is the High Court. Now let's move to the next question attached to this one. So suppose whatever the reference has been given by the High Court. So the court who has sent the reference, that court is bound by the decision of High Court or not? I'm repeating myself. The court that has sent a question in the reference, that court is bound by the decision of High Court under reference or not? Answer in the comments. Aprajita, yes. Yes. The answer is correct. The court is always bound. In bailable offense, the bail is granted as a matter of right. Not more than 2 seconds. If you are taking more than 2 seconds for this question, you have not studied CrPC. So the answer is both A and B because it's a bailable offense. So the bail can be granted as a matter of right by the police officer or by the court. Who may grant the anticipatory bail? When it comes to UP Judicial Services, anticipatory bail is one of the most important topic. Top 3 students to answer correctly. Pariksha, Dharitri and Aprajita. And everyone's answer is correct. That when it comes to section 438, both High Court and Court of Session can all grant the anticipatory bail. Okay, let's see if you can answer this one. This may be asked in your interviews. Can Supreme Court grant bail? Yes. Can Supreme Court grant bail? Answer in the comments. Yes or no? And if yes, under which provision? Samsudua Khan, correct answer. Supreme Court can also grant bail, okay, when it comes to special leave petition, SLPs, through SLPs, okay. Next. Correct answer, Levy, through SLP. ठीक है जी. Offense is punishable with fine only. The period of limitation for taking cognizance of it shall be. One of the most important section number. Do mention the section number as well. There are 99% chances that you will get question from this section. Shalini, Aprajita, please do correct yourself. It is not 464, 468. Dharitri, 468. Correct. So that is of 6 months. Filing FIR is a condition precedent to exercise the power under section 438 CrPC. Choose the most appropriate option. Top 3 students to answer correctly. Rupinder Kaur, followed by Vandana and Laila. So it's completely a false statement, students. Lodging of FIR is not a condition precedent for your anticipatory bail. A person who is granted bail under section 436 CrPC fails to comply with the conditions of time and place of attendance on a subsequent occasion. If this is the case, what are going to be the consequences as per to your options available? Yes, please. So 436 is basically where bail is as a matter of right. Top 3 students to answer correctly: Aprajita, Kanika, and Levy. And I guess everyone's answer is correct. Vandana, please do correct yourself. B is not the correct answer. See, when it comes to bailable offense, bail is your right. But if you fail to comply with any of the conditions, then we are not going to consider that as a matter of right. And the court may refuse to release him on the bail. So both B and C is the correct answer. Okay. No woman shall be arrested after sunset and before sunrise except obtain prior permission from. Do write down the section number as well and the clause as well, if you can recall. Section number is easy one. If you can recall the exact clause as well. Top 3 students to answer correctly: Jyoti, Shalini, and Aprajita. Dharitri, correct answer, section 46, clause 4. Lavi, correct answer. Yes. So judicial magistrate, first class. If the proclaimed person does not appear within the time specified in the proclamation, the property under attachment starting from Pratyush, followed by Dharitri and Aprajita. Everyone's answer is correct. That is A, 6 months. Can anyone tell me the reasoning why 6 months? Can anyone tell me the reasoning why 6 months? Yes. Be quick. Why 6 months? There is a reasoning behind that. Wonderful. Pratyush Kumar. Completely correct answer. So see, students, when it comes to section number 82, that is basically your proclaimed offender. When it comes to section number 83, this is your attachment. When it comes to section number 84, that gives you 6 months. Okay, so if anyone wants to claim, okay, or any objection over the attachment. And when it comes to section number 85 as well, there it has been written that the court cannot sold it until the expiry of 6 months from the date of attachment. An arrest warrant in the criminal case shall be signed by. If you can recall the exact language of section 70, you can easily answer this question. Okay. Aprajita, Pratyush, and Neha, top 3 students to answer correctly. And C is the correct answer. Okay. Yes, C is the correct answer. And suppose if the B option is any of officer appointed by the High Court and the D option is both B and C, what is going to be the answer then? If I just change these options and on option number B, there is an officer appointed by the High Court and option number D is both B or C, then the D is going to be the correct answer. Okay. So basically these kind of questions basically judge that how much you can recall from the Bayer Act in the examination hall. Period of appearance for proclamation issued under section 82 is not less than Aprajita, Dharitri, and Shalini, top 3 students to answer correctly. Pratyush, please correct your answer. This is 30 days, not 60. Okay, can we send proclamation? Can we issue proclamation without warrant? Yes or no? Can we issue proclamation without warrant? Yes or no? Aprajita, no. Shalini, yes. Tharigoti, yes. Sorry if I have mispronounced your name. So I just call you TA. So TA is answering yes. Dharitri, no, yes. Okay, whosoever is answering yes, please give me your reasoning. Please give me your reasoning. Where it is written, under which section? If you are saying that proclamation can be issued without warrant, please tell me your reasoning behind that. Under which section? Exceptional cases. No, Shruti, there are no such exceptional cases. Now, let me tell you the answer. The answer is when you will read section 82, you will find out that in the language of section 82, it is said that warrant is one of the most important essential. Once the warrant has been issued and the court then has reason to believe that the person is not going to be arrested, then they can go for the issue of proclamation. But without warrant, no. And you can read section 82 for that. I think the clause 1 only will give you the answer to this question. Okay? Fine? Chaliye ji. Next one. If you get this wrong, okay, I do have one interesting question in relation to this as well. Okay, first you answer this one. After that, I'll give you one application based, or you can say a difficult question for this concept. Okay, everyone is answering D. I don't think it's like difficult for you. So section 57 is the correct answer. Now, who can tell me why the person who has been arrested, he needs to be presented before the magistrate, and that is also within 24 hours. So basically, I'm asking you the reason why do we need section 57? Why? Yes, please. Habeas corpus. No, that has nothing to do with habeas corpus. 167. No. No. Come on, it should not be that difficult. Yeah. Aprajita and Levy, somehow I am, I can accept your answers. Bail is a right. Okay. See, students, now I'm telling you the reason. The reason is when you will read section 4, starting from section 41 till section 60A, that includes the procedure of arrest, who can arrest, what are the rights of arrested person, what are the duties of police officer while making the arrest. Now, section 57 will ensure that whatever the duties of the police officer, whether that has been performed or not, whatever the rights of the arrested person that has been given to that person or not, whether that arrest is legal or illegal. So that's why within 24 hours of arrest, he needs to be presented before the magistrate. Okay. I hope now it's clear. Next one. And if you still have any doubts, feel free to ask questions in the comments. Maximum monthly maintenance. Be quick. Okay, everyone is answering D. Okay, that is, there is no such limit. Now let me ask you this as well. What is the maximum monthly maintenance under Maintenance and Welfare of Parents and Senior Citizens Act? If you have gone through with that special law, what is the maximum monthly maintenance under Maintenance and Welfare of Parents and Senior Citizens? Only Nawab Khan has gone through with the special laws. Nawab Khan and Kanika. Correct answer. Students, I have taken all these till now I'm done with 3 of your special laws and in the special classes only. So you may go through with those classes, and in those classes first I have explained you the concepts and then the important MCQs. So you may refer all those special classes, and that's something which is completely free of cost. Okay, moving towards the next question. When a complaint is presented to a magistrate and the magistrate proceeds to examine the complainant and the witnesses under section 200. Total questions 20. Next is going to be the last question. Dharitri, how can one process can be part of investigation and inquiry both? See, the term investigation has been defined. And when it comes to the okay, the term investigation has been defined under section B is the correct answer, students. Yes, 2H. So 2H define the term investigation. So that has nothing to do with investigation, has nothing to do with the court or the magistrate. So whenever whatever the examination is taking place under section 200, the magistrate is basically conducting an inquiry. B is the correct answer. Last question. Most repeated one in your exams. Who among the following is authorized to record confession under section 164? Pratyush, Divi and Levy, top 3 students to answer correctly. Yes, Jyoti, Metropolitan Magistrate or Judicial Magistrate first class. Now, anything which you are not clear with or still have any doubts, you may ask before concluding the session. So this is the link of my profile where you can get all the classes on special laws. Okay. And this is the link of my Telegram channel. If you have any issues in finding the link of those classes, you may put your questions here as well and I'll share the links. This is my code Khatri10, which you can use to get free access of all the special classes available on Unacademy app. So let's crack PCS J with Unacademy. This is the batch which has been recently started, rapid revision for UP and Chhattisgarh Judiciary. And I hope as of now everyone is aware that the date for UP Judicial Services examination is out, and that is of your 12th of Feb 2023. This is the Prarambh batch starting from December of 27. This is the Sankalp UP PCS J prelims batch already started from December 17th. This is the revamped test series for this December. This is the Plus and the Iconic subscription for Unacademy. This is the Articulate coming soon monthly current affair magazine. These are the YouTube channels of Unacademy and these are the Telegram channels of Unacademy. And that's it from my end. Chaliye, you all are welcome. Okay, Levy, for the next time I'll add some more questions to that. Okay. So, see you in my next class. Till then, yes, it's time to say peace.